Welcome to TaxWith's Wealth Protection Podcast, where we demystify the legal and tax issues surrounding wealth creation and protection. The content presented in this podcast is for informational and educational purposes only. Should not be construed as legal, financial, or tax advice. While the hosts and guests may be legal professionals, they are not your legal professional. Laws and regulations vary by jurisdiction, and the information discussed in this podcast may not be applicable to your individual circumstances. Always consult with a qualified professional for advice tailored to your unique situation.
Today's episode is all about how to structure your living trust based on your personal circumstances. So Whitney, if you could kick it off and just walk us through what is a living trust and what purpose does it serve in modern estate planning?
What purpose does a living trust serve in modern estate planning? Good question. So let me put it this way. So when I was a kid, Howard Hughes died, and shows how old I am. And I was, 10 or 12 at the time. And I remember in the news, there was all these reports. There's, I think, 12 or 18, there was like 18 people that came out of the woodwork that had a will. I get $1 million. And, the server at the Big Apple, let's eat. And the guy that worked at the gas station on Route 66. And so a whole bunch of them came out. And I think like a dozen people actually got their $1 million because he signed, several codicils saying, and I give you $1 million to different people. But in today's world, the will is a side event. It's not the main course anymore because a will requires a probate. And so a lot of times in estate planning, we're trying to avoid probate. So a will, probate is a derivation of a Latin word that means to prove a will. So when you have a will-based plan, for sure, you have to go to probate and, court administration and supervision and all this type of stuff, and everything's public information. So a trust is, the purpose is, and what is it? The trust is generally we're trying to avoid probate. So we title ownership, but it's title of our assets into the name of our living trust. And so any assets that are titled in the name of our living trust, well, they don't have to go through probate to transfer to the beneficiaries. And while we're alive, we don't have a problem with the conservatorship or guardianship because the trustee of the trust can transact on trust assets and manage trust assets immediately. And so we don't have to worry about what people call living probate, the conservatorship and guardianship problems, which is terrible. Everyone wants to avoid that. It's expensive and frustrating, and court-appointed lawyers and counselors make all the money, is what happens. So in a living trust, we're trying to avoid that. We want to avoid probate when we die. We want to have a means for making sure that our trust, our assets can be administered privately, immediately, without delay, without court intervention or supervision. And there's a lot less contention. So we don't have nearly as many trust litigation, trust disputes as you do when there's a probate. Because it's easier to file a lawsuit in a probate than in a trust, because a lot of times a trust has no contest provision. And so the trust-based estate plan really is the main event today. This is the centerpiece of your estate plan. And then the will is kind of a side event. And then there's other documents that kind of pull it all together. It's a safety valve, catches the assets not in the title in the name of the trust upon your death, puts them in your trust, but the trust is the main event.
Okay, so you touched on some of the roles of different, trusted persons in the estate plan. So you have your trustee who, steps into your shoes if you're incapacitated, manages those trust assets, pays your medical bills, that sort of thing. Then you also mentioned, the executor or the personal representative appointed in your will, who would only, have anything to do if some assets are left outside of your trust, and those assets need to, go through the probate process to be put in the trust.
Right.
You also mentioned the guardian. So that's the person, responsible for raising minor children, if there are any. Uh, a couple more roles that, are in these estate plans. There's the financial power of attorney and there's the healthcare agent. So could you explain for me how those two differ and where they come into play?
Okay. So in your estate plan, it'll be a will, a trust, and a set of other documents. While you're alive, if you are incapacitated and you can't speak for yourself, then you have a healthcare power of attorney. That's the person who speaks for you to make medical decisions if you can't make your own medical decisions. The most difficult one, of course, really is, should we pull the plug? Is it time to remove the life-sustaining equipment and let you die with dignity and naturally? And when is that time? And that's the most difficult. But that would be technically the healthcare power of attorney that would have to make that decision. Um, Now, there's a durable power of attorney or a financial power of attorney, and you'll have a document. Usually it's called the springing durable power of attorney or something like that. The document doesn't take effect until the principal becomes incapacitated. And once the principal is incapacitated, then this financial power of attorney springs into action. And then you have a financial power of attorney. This is someone that can sign your name to transact your personal business, to sell your car, to sell your house, sign contracts, to file a lawsuit, to, settle a lawsuit, to make, an insurance claim and those types of things. So if you're incapacitated, then you need to have a financial power of attorney or a power of attorney. Sometimes they say an attorney in fact, that can sign your name, sign to, your tax return and various things like that. You mentioned some of these other roles, and maybe it's not a bad idea to go through them. So, because when we do estate planning, a lot of people ask me, well, who should be my guardian? Who should be my trustee? Who should be the executor of my estate? And usually in Arizona, we don't have anything called an executor. It's called the personal representative. In a lot of states, it's called the personal representative. I think some states still use the nomenclature of executor and executrix, but who should be in those roles? And those are different roles. And you do want some separation of powers and separation of duties, some basic internal control structure. So let's talk about that. The guardian. The guardian is the guardian of my minor children. And so this is, if I were to pass away and I have a child that is 10, who's going to be the guardian? Who's going to essentially parent that child and take custody over that child? And so we're going to name our guardians. And it's kind of interesting because, usually when we're doing a estate plan, clients will ask me, they'll say, okay, so we're going to have, Mr. and Mrs. Jones as the guardian of our children. And I say, well, is it Mr. Jones or is it Mrs. Jones? Or is it, because what if they're divorced, then they're going to argue and go to court, see who's going to be the guardian. And that adds, problems you don't need. A lot of times what we'll do is we'll say, Mr. and Mrs. Jones, so long as they're married. And if they're not married, then Mr. and Mrs. Smith. And if Mr. and Mrs. Smith isn't married, then it's Mr. Jones. And if he can't do it, then it's Mrs. Jones, So, but the guardian, this is someone with parenting skills. The person is basically going to raise your kid. And as opposed to the trustee or personal representative, the trustee of the trust is going to handle all of the trust assets and follow the directions and manage, those investments. And so there's a lot more business skills that we're looking for when we're naming a successor trustee. Next question would be, okay, so I'm going to name both of my kids, my son and my daughter, as co-trustees. And we see that sometimes. Not a good idea. It's generally a better idea to name one and then the other. Because when you have two people, now the bank won't take a particular document unless both of them sign. And maybe one of them lives in, Kansas, and the other one lives in Florida. Now we got to circulate things for signatures all over the place. Some places will take a DocuSign, which is quick and easy. Some places, some things, like if it's a broker, some things need a wet signature, so, and then maybe they don't get along. Maybe they don't agree on things. So it's generally better to name one person as your trustee, and then the second person if that first one doesn't work out. And then if you want to name a third, you name a third. So trustee, guardian, healthcare power of attorney, financial power of attorney. We talked about those. And now personal representative of the estate. Basically, most people will choose the same person to be the personal representative of their estate as they do the trustee. And, in most cases, if we do our job correctly and we properly fund the trust, meaning we transfer title to our assets or of our assets to the trust, then we avoid probate. But in the case we do need to open a probate for various reasons, and sometimes we do, and sometimes we do it purposefully. No, I can talk to you about why that might be the case, if you like. But if we do, well, we a lot of times, that same person will be there. But being that generally we're avoiding probate and the personal representative won't do anything because we're not going to open a probate, sometimes that's a great place with a big title. I'm the executor of the estate, that doesn't do anything. And that comes in handy because, and here's for an example, a client comes in and says, our oldest son, we just don't want him really in control of very much. He's well-intentioned and we love him, but he is the least able of our children. And our youngest daughter, well, she's the business minded, she's the stronger one. She's the, more successful. She's able really to handle the job. And we really want her, but we don't want to, upset our son. And so we want to include him somehow, somewhere. And so when we hear this, fairly often, and so a lot of times we'll say, okay, great. So we'll make that son the personal representative of the estate, where it's a big title, doesn't do much. And at the end of the day, his job really is to get all the assets and put them in the trust. And then the trustee of the trust takes over and does everything, right? So that's, one option if you have that problem and you're like, I don't want to upset, this one kid. So let's give him a title, but hopefully he doesn't do anything. So that's one option. So what are some other titles? There's trust protector. Trust protector is something that's, relatively new in the grand scheme of things. We've seen this over the last, 20 years. More commonly, a trust protector is not a trustee, is not a beneficiary. So the trust protector can remove and replace a trustee, can amend the trust to conform to new laws that render some of the provisions in our trust, ineffective. And so if there's a new law that comes out that stops the asset protection, language that we have in the trust, and we want to continue to make sure that we have, asset protected trusts for our beneficiaries, well, we can amend the trust to use whatever language is necessary so that the trust now has that asset protection in under this new statute. Or sometimes we'll see where we'll have a special needs trust, for example, for a special needs child, or someone that is receiving benefits for whatever reason, welfare or disability benefits. And every state has their own set of rules for how to qualify for that. Well, what if a beneficiary moves from, Arizona to Texas or Wyoming, and it's a whole different set of rules, and the way that the trust is drafted, well, now the special needs trust no longer works, and, the special needs child loses his benefits. So in that's another example of where the trust protector can amend that trust to conform the special needs provisions that applies to that particular beneficiary to the new law or the new state where he or she may live, so that the child or the adult that is special needs is able to continue receiving any state benefits. Most states have statutes now that have codified the trust protector provisions position, and but it's an important position. We generally recommend that if your trust is an irrevocable trust or is going to become an irrevocable trust, that trust probably should have a trust protector or a mechanism for appointing a trust protector, because the trust protector can come in very handy and solve problems. So I think that's most of the positions.
Yeah, one more that I'm sure if you're researching estate planning options out there, you'll run into, the grantor or the trust maker, which is the person who's creating the trust.
Yeah, right. So, I came out of law school. I worked for this fantastic lawyer named Joe McCabe. He did a lot of real high-end estate planning, and I did all this tax research for him. And, I was researching, family limited partnerships and grantor retained annuity trusts and qualified personal residence trusts and NIMCRUTs and TCLATs and all this really, high-end sophisticated estate planning stuff. And, after a year and a half, I had no idea how to draft the basic living trust, right? After years of, doing all this research on these really sophisticated estate planning topics, I knew nothing about the basic living trust. I didn't do any of the, base planning, until later in my career when I, went through some different types of training and with the National Network of Estate Planning Lawyers, and went through some of that training. It's just taught me really a holistic approach to estate planning. But I didn't understand the basic living trust. And I remembered Joe McCabe came in my office one day and he goes, "Hey, Whitney, look at this trust and tell me if there's a credit shelter trust." And I was thinking, a credit shelter trust? What is that? So I'm looking through this trust. I'm looking for these words, credit shelter trust, and I didn't see one. Here's what happens when you are talking to estate plan lawyers or reading on the internet about trusts and estate planning. You're going to see a bunch of words, and there's a lot of words that mean the same thing. They're interchangeable. So let's go through them. The settler of the trust, that's the person who forms the trust and puts assets into the trust. Also, the grantor is the settler. Also, the trust maker is the settler. So you might see grantor, you might see settler, you might see trust maker. That's all the same thing. So what happens in a living trust is when we have, a husband and wife and our married couple. So when one person dies, the assets are generally split into a couple of pieces. And so the surviving spouse will have the survivors, half of the assets and any sole and separate property. So half the community property and sole and separate property of the survivor. And then the dead person has their half of the community property and sole and separate property. And those assets may then be split in between two different trusts. One is commonly referred to as the credit shelter trust, and the other is commonly referred to as the Q-tip trust. And these serve specific purposes. So the credit shelter trust, some people call it the bypass trust. We call it the family trust. Some people call it the B trust. It's like vehicle, car, and automobile. Different words that refers to the same thing. So what is that? Basically, in the bypass trust, you are giving the assets to the children, but holding them in a bypass trust so that the surviving spouse has access to the income and maybe the principal while they're alive, so they can always make sure that they have enough money to pay their expenses while they're alive, right? And then when the survivor dies, the remaining assets in the bypass trust go to the children, and there's no estate taxes on those assets. People call it the credit shelter trust because you are sheltering the assets in that credit shelter trust from estate taxes by the amount of the lifetime credit that someone has, that you can give this much money without there being estate tax, right? We call it the family trust because we don't like these, weird terms like Q-tip and stuff. That the family trust, I tell my clients, that's the money you're giving to the rest of your family without the estate tax. So you're using your estate tax, maximum amount, your lifetime exclusion, and you're giving that money to your family members, your children, or whoever are your beneficiaries. But we're going to hold it in trust for your surviving spouse so that make sure that they have the money while they're alive in the case they need it. And then we have the other one, and I said Q-tip. So we have this word called the Q-tip trust. We call it the marital trust. Q-tip is an IRS reference. Qualified terminal interest property is what Q-tip stands for. It's not something that you use to clean out your ear. We call it the marital trust because it's just easier, because basically what we're doing is, if we are basically giving those assets to our spouse, and on the estate tax return, the IRS allows a marital deduction. And so you can give all the money that you have under the lifetime exclusion amount, your credit shelter amount. And if you have more, then if you give it to your spouse, well, there's no estate taxes on any money you give to your spouse. You can give $1 billion to your spouse, there's no estate taxes. The estate tax will be applied when your spouse dies. And so so the assets we're giving to our spouse when we die go into what we call the marital trust, and because we get the marital deduction on the estate tax return for those assets. If you see Q-tip, marital trust, that's the same thing. The marital trust, in order to qualify for Q-tip property, the marital trust must require all of the income goes to the surviving spouse. It doesn't have to allow the surviving spouse to get access to the principal, although it can. But the marital trust must allow all the income to the survivor for the survivor's lifetime, and there's nothing that can stop that in order to qualify for the marital trust treatment. Upon the death of the surviving spouse, then anything the surviving spouse owns at their death, plus all the assets in the marital trust, add that together, and whether or not there's an estate tax will depend on the total amount in those two trusts. The survivor's trust plus everything in the marital trust, add that together, and that's what's subject to estate taxes when the surviving spouse dies. So I didn't understand this Q-tip, and then so when Joe McCabe comes to my office, says, I look through it, and I'm like, there's this thing called a bypass trust, and there's this thing called a Q-tip trust, but I don't see any, credit shelter trust. And he's like, yeah, okay, well, I didn't get it, but I do now.
Okay, so that was a good primer on, what are the different, would you call those sub trusts? Or
Well, yeah, I mean but they break up. I mean they don't become effective until someone dies.
okay.
And in banks and title companies and brokerage companies have a hard time with this because it's the Whitney and Diana Living Trust, okay? And we're alive. And so we have assets titled in the Whitney and Diana Living Trust. But then when I die, the trust says, okay, upon the death of one person, split everything up. The survivor gets everything in the survivor's trust, and the dead person's assets will be divided amongst the marital and family trusts. And so the banks and brokerage companies, they have a hard time because everything's still titled in the Whitney and Diana Living Trust. But technically, that trust is a legal fiction, because as soon as I die, it goes away, and these other two trusts spring into effect, right? And so usually what we'll do in our trust to make a smooth transition is we'll have an article that says, all right, look, upon the death, the Whitney and Diana Living Trust goes away, but we have to recognize the fact that, we haven't retitled all the assets yet, because he just died like 3 seconds ago. So none of the assets have been retitled into the family trust, the marital trust, and the survivor's trust. So, hey, banks and brokerage companies and everyone, if it makes it easier for you, just refer to it as the administrative trust for now, and allow the trustee to do whatever the trustee needs to do as set forth in the trust instrument, and then give them time to make elections and have a funeral and, figure out how they want to allocate things, and then, allocate things later. And so that's how we deal with it in the trust instrument, so that there's a smooth administration, and the banks and brokerage companies don't, have a fit.
So how does the living trust structure different if it's for someone who's unmarried, if it's for a
Okay.
single person?
Well, if it's unmarried, then you don't have the surviving spouse issues. So when the person is unmarried, there's not going to be a marital trust. There won't be a family trust. So when a single person, Whitney's living trust, and Whitney dies, then there's going to be an administration period, and so we'll even call it the administrative trust, and so that still stays in the meantime. And so we will, pay my last debts and file my tax returns and make tax elections and, pay expenses of my administration and do those things. And then we'll allocate the assets into, trusts for the beneficiaries. So instead of being held in a family and marital trust for the benefit of the survivor, and then when survivor dies, it drops down to the kids. Well, I die, I'm unmarried, my trust just drops right down to the kids after administration. And then I'll have, 3 sub-trusts one for each of my kids. And then we'll have the provisions in their trust, and then it goes along.
What about blended families?
Yeah.
How does the structure differ there?
This is one of the reasons why you just can't get the standard form from any lawyer or financial planner or CPA handing out cheap living trusts, because there's a lot of different ways we will draft a living trust based on, circumstances. And this is a great example. So let's have the Ward and June Cleaver family with Beaver and crew. So we have the nuclear family, husband and wife. They've been married for 50 years. They have children together. There are no children outside the marriage. All of their children are together. All right. Well, they kind of have the same goals and the same kids, obviously. So there's less risk that upon my death, if I'm holding assets in trust for my spouse, they're going to end up giving all my assets to someone else other than my kids when they die. Whereas if we have a blended family, so we're talking the Brady Bunch, we have my kids, your kids, and our kids, right? And this is most clients, honestly. So here's the problem. I have my 3 boys and you have your 3 girls. And when I die, I say, hey, I'm going to leave all this for you while you're alive. And then when you die, it'll go down to the beneficiaries of the trust. And, we name, all 6 kids as equal beneficiaries. But I'm dead. And after I die, mom, changes the trust and says, hey, by the way, all of my assets are going to go to my 3 kids. And my side of the trust said, when I die, it goes to all 6 kids. So this is a problem. So there's a fundamental different way we would draft a trust for a blended family than we would for the Ward and June Cleaver family. So in a blended family, we're going to remove any powers of appointment. So powers of appointment are commonly seen in living trusts. And the power of appointment says that the beneficiary, and if it's the wife, surviving spouse, may have the power to reappoint the beneficiaries of the trust. So if there are powers of appointment in the trust instrument, I die, my assets are in the marital trust and family trust, and the surviving spouse can reappoint the beneficiaries of those trusts to be her kids, and then she can disinherit my kids. And, look, we have a lot of contentions with this, kids and, new spouse. Sometimes, the kids see that new spouse in, unflattering ways because of the way that their mom was divorced, with their dad and that sort of thing. But it could also happen where, mom or the surviving spouse is now 88 years old, has, some form of illness or dementia. And one of the kids is the one that takes off work and spends time to care for, the parent, and is there helping them eat and make sure they, take their medications, and drives them to the doctors, and, does the work around the house, and helps them use the restroom, and all of those things. And then they say, Mom, I'm not working, and I'm here, caring for you. And it's only fair that, you leave the assets to me to make up for that, because, my brother and sister, well, they're living in Florida, working and doing well and thriving. And here I am, not being able to do that. And to some extent that has legs, but, that happens in a lot of varieties. And we see the surviving spouse in those types of circumstances changing the beneficiaries all the time. And more often than not, it is not resulting in a conclusion that they contemplated or agreed to when they were younger and prepared their estate plan. So we need to draft those trusts for a blended family very different. We don't want to allow the survivor to disinherit the kids of the dead person. So there's a lot of different ways we would draft that trust that would be different. A lot of times you'll see this in a trust. Pay to my surviving spouse all of the income for life. Well, in the marital trust, you have to, but in the family trust, or the Q-tip, or the family trust, the bypass trust, or the credit shelter trust, whatever you want to call it, it might say that. And here's the problem. If my surviving spouse is the trustee of the family trust, and surviving spouse gets all the income, surviving spouse is probably going to invest those assets into income producing investments. Well, income focused investments are not growth investments. And so we don't have any growth in that portfolio. And so we all know that in modern portfolio theories of financial management, we want growth. Growth is good and important. And so now, but we have mom, or even if it's a trustee, under pressure to invest those assets so that we generate a lot of income, for the surviving spouse. Meanwhile, the children of the dead spouse, they are not the children of the surviving spouse. They want exactly the opposite. They want those assets to grow because they don't get them until, the spouse is dead. And so they want those assets into growth assets so that they keep up with inflation and they grow, and there's a bigger amount of assets there. when surviving spouse dies. So what does the trustee do? Does the trustee invest in the growth assets, which is what the beneficiaries, the remainder beneficiaries, the children want? Or do we invest in, income producing assets, which is what surviving spouse wants? So we have a built-in conflict of interest that creates a problem. Now, think about this. This is not the mother of these children to begin with, and there's already potentially that conflict. Now we're going to build an additional financial conflict where they want two exactly opposite things. And this isn't really the best thing to do in a living trust, to keep family harmony. So another thing that we'll do that's different in the Brady Bunch version of this estate plan, we will use what's called a unitrust. So the fix to this blended family trust issue and the all the income to survivor, the fix is this unitrust concept. We have this unitrust. The unitrust says survivor gets 3% of the trust assets every year. The survivor now understands that 3% of a bigger number is a bigger number. So the survivor wants the value of the trust assets to grow, right? And the kids want the value of the trust assets to grow. Now, what we've done with this unitrust is we've aligned the interests of surviving spouse and the children of the dead spouse so that we've removed the conflict, and now both of them want the assets to grow. Plus, modern portfolio theories of financial management tells us we want growth. And so now we've aligned all the interest, and we can invest assets into growth assets and still make everyone happy. Let me tell you, the blended family trust, when I see clients walk in my office and they have an estate plan from another law firm, and this is a blended family, I would say probably 1 out of 4 have a trust that's properly drafted and doesn't allow the survivor to disinherit the children of the dead person. And that's a big problem. It happens all the time. And that's, we see so much litigation, and this is easily fixed, but this is another problem of the standard form law firms that really don't understand estate planning all that well. But, they have someone that's got some forms from a bank form book, and they're doing estate planning. And, so we see this problem all the time.
Yeah, it sounds like definitely the power of appointment issue that you mentioned would be pretty important to fix.
Remove the power of appointment.
So what about planning for minor children? Are there any common techniques that you use to kind of make things more efficient in terms of administering the trust or administering the trust, or is there any special provisions that you put in there when minor children are involved?
Well, so we have a couple of problems with minor children. I was with a client this morning, and they're a fairly wealthy client, but the father has a child. She's 27, and then the couple together has children together, and those children are 10, 12, and 14, right? And so let's say that something were to happen to the parents, coming home from vacation, and, we have this fiery Malaysia airline plane crash that, goes down to Gilligan's Island, and we don't hear from them for, decades to come. And this particular client, and most clients, they'll say, we want to be fair to all of our children. So we want all of them, even if it's from my first marriage or my second marriage. I want to treat all my kids the same. Well, equal is not fair, really, because think about it. So we have 25%. So let's say we have, $2 million. That means $500,000 for each kid. Well, if that's the case, the 27-year-old kid had the luxury, the parents paid for her to go to college and bought her a car when she turned 16 and bought her, phones and, computers for school as she needed from time to time. And when she got out of school, she got married, and the parents paid for the wedding, helped her with a down payment on their first home. So there's a lot of things that we do to support that kid, especially when they get older and they get up and out of the house. And, some people come back to the house and we get them up and out of the house again. And, so when we're parents, we pay for these things. This is, part of raising kids. Not everyone does, but a lot of parents do. And so the 27-year-old got the benefit of that. Now, the children who are 10, 12, and 14, and they have $500,000 in their trusts, there's going to be no money in those trusts by the time they get out of college. If they even have enough money to get through college, they probably wouldn't, at their rate today. I mean, they've got to pay for, their personal living expenses through all those years as a child. So it's just not fair, right? So when we have minor children, and this particular issue I'm talking about is when we have minor children with disparate ages. So we have a big age gap between one child and the rest of the children. So it's not fair. And so what we'll do in those circumstances in the fix is to have what's called a common pot trust. People call it a common trust or a pot trust, or we use the term education and support trust is what we call it. And so basically what we're doing is we're going to simulate that mom and dad lived to life expectancy. So, if mom and dad lived to life expectancy, well, all of the kids were, 35 or 45 by the time mom and dad died. So let's simulate that. So basically the education support trust is going to hold all of the assets in one pot. And we're going to continue to pay for the things that mom and dad would be paying for. And, the 27-year-old, she's married and has a kid and has a job and a college education and her own house, and she's living her life. She doesn't, we're not supporting her anymore, but we have these 3 younger kids and we're going to support them. And so we're going to have the common pot trust that will have some instructions to the guardian and trustee that says, hey, use this money to pay for our children as if we were alive. And what would that look like? Well, we're going to have our children go to school or go to private school and go to university. We're going to buy them a car. We're going to get them a phone. We're going to get them a computer. We're going to send them to summer camp. Maybe there's, music lessons. Maybe they have other scholastic or athletic or, artistic, interests, religious interests. Maybe they want to go, on a summer mission. Maybe they want to go to Europe and backpack across Europe one summer. There's a lot of things that we pay for as parents. So let's continue to do those things, get them a car and put them through college. And then when the youngest turns 25 years old or graduates from college, whichever happens first, that's the triggering point. You can use whatever number you want, whatever age, whatever metric you want, but that's a common metric. And at that point, the common trust terminates. And then we fund the separate trusts for each of the kids. And so, all the kids get their 1/4 interest of whatever's left at that time. And that's fair. Now we have a fair way of dealing with a scenario where the parents die at an earlier age than we hope or anticipate. But there's other problems. So that's one problem. Other problems when we have young children. And so let's talk about guardianship first. So the other problem with kids is, we need to appoint a guardian. Okay. So, and it's not always the easiest thing because you have to have someone that's willing to take your kids and parent your kids. And, it's a big job, as we know. But also we need to give our guardians some guidelines, So I think back, Ben, to the first time that my first wife and I had a babysitter. So I think our child was like 8 or 9 months. by this time, we couldn't leave the kid, our baby. We couldn't leave our baby, and we never did. And about 9 months, we thought, all right, let's go have a date. I think we can, leave our child to babysitter for a couple of hours. So we get a babysitter, and we go out. Well, when the babysitter comes over, mom gives like a 15-minute dissertation. Here's my phone number, and here's Whitney's phone number, and here's the phone number of the restaurant where we're going to be, and this is the phone number of the movie theater where we're going to, and here's my mom's phone number, and here's Whitney's mom's phone number, and here's my brother's phone number, and here's our next door neighbor's phone number, and their name is so-and-so, and here's this bottle, and here's the other bottle, and here's these different nipples. Well, the baby doesn't like these nipples. She only likes those nipples, so make sure you only use those nipples. And here's the Similac, and then here's the breast milk. And then we have some breast milk all out here ready to go. But if she's eating and you need more breast milk, then it's over here in this freezer, and you're going to put it into I'm not joking. She goes literally into at least 15 minutes and maybe longer of a dissertation for all of the, things. And we're going to be gone for literally, 4 or 5 hours. Well, I have clients walk in my office with their estate plan, and they might have named their guardian, and I'm reviewing their trust with them. They've named their guardian. There's no instructions at all. The guardian is going to take control of your kids and your money forever. Not forever, but for until they're up and out of the house, and you give them no instructions. And so I see this as a big problem. And so we'll sit down and we'll talk about it. And what instructions would you want to give someone who's going to spend your money on your kids? Might you have some ideas of how you want your money spent? Because if you don't, here's some things that we've seen. There is a $1 million life insurance policy. It pays out into the trust, and there's some other assets in the trust. And the guardians say, hey, we've got these 2 extra kids. We need a bigger house. We need a bigger car. So we go out and we use the trust monies to buy a Cadillac Denali XL. And we get the nice SUV for all the extra kids. And we got to buy a new house. And so we're going to look at Camelback Mountain and go spend, $1 million down payment and take $1 million mortgage on a house on the top of the hill on Camelback Mountain. And we're like, hold on a second. That's not why we bought the insurance policy. The insurance policy is to make sure my kids go to college and make sure they have medical attention and the best medical care and other assets to start their life. And that's what the money's for. And so we need to give some instructions for how to spend our money and how to raise our kids. Some people will say, hey, there are certain religious preferences. They prefer that their kids go to private school or they don't. They prefer that their kids have certain types of experiences. They prefer that their kids spend time with their, cousins and things. And so it's a good idea to give some instructions for how you will raise your kids and how you would allocate, budgets and monies for your kids. So that's the guardian issue. And then we have the incentive issue. So we have minor children. Look, when all the kids that are 5, we aspire these kids are going to grow up and be the president of the United States or the most successful person, that in our family that we can imagine. This is the one, right? But especially if we're not there to raise them, we don't know how that kid's going to turn out. And even if we raise our kids, we never know how they're going to turn out because there's so much that society influences these children. There's so many opportunities for that child to get derailed. And, next thing you know, there's a substance abuse issue or whatever the case is. So there's so many dangers in the world and problems. We probably need to give our kids some incentive. So we call these our values, right? We have values. And we all have our different values. And some people's values are more guided around being successful financially or being successful in personal relationships or being successful in certain religious ideals and whatnot. So we all have our different values. And so we like to build a trust that rewards the kids for maintaining those ideals and maintaining our values. And then the other problem is money ruins kids. So, I remembered as a young father, we would take the kids on 4th of July to this one particular resort, and they shot up the fireworks right there, and it was really nice. And it was right here in town, and it was kind of funny because we'd be, at the pool, and we'd, meet all these other people and all the kids and all the parents, and like everyone was from, Scottsdale or, Phoenix or Tempe. Oh, you came far. You're all the way from Tempe. And then there's this one young woman. Her kid was like 4 or 5. The woman was drunk and buying people drinks, and then she's got this kid, and other moms are really caring for this kid. And she says, it's okay, I'm a trust fund baby. And I looked at my wife and I was like, that's why I have a job, because this is what happens. You hand $1 million or $5 million to an 18-year-old, and money has a way of ruining people in a lot of different ways. So when we have young kids, we probably want to build that trust so that they don't get a lot of money at the age of 18. We probably want to give them, I think it was Walton who said, I want to give my kids enough money so that they're able to do anything that they aspire to do in life. But I don't want to give them so much money they end up doing nothing. And so we really don't want our kids to, sit around on the couch smoking some whatever they're smoking. And boy, if you get to be the age of 25, you get a third. If you, somehow survive to turn 30 years old, you get another third. And boy, amazingly enough, you reach the age of 35, and here's another third. That's really not the way that most people would parent a child, right? And so our trust can speak to values, and we can incentivize our children to be good, contributing members of society, to pass along our values to them so that they have the best opportunity for living a rewarding and healthy life, right? And those are really the biggest problems we see when dealing with minor children in an estate plan, and then realize, look, we're building this trust for the circumstances that exist. Hopefully, we nothing bad happens, and the fiery Malaysia Airlines crash doesn't come to us, right? And boy, when our kid now has gone from 5 to 15, and we see how that child is shaping up, when we can amend our trust to speak to the issues existing at that time. And then when our kids are 25, we can change it again. So we can change our trust from time to time. But when the people come in and their kids are, 3, 5, and 8, we think about what worst case scenario. My job as a lawyer is to protect you from worst case scenario. And so we want to, address the issue. What happens if something happened to the two of you at a young age? That's worst case scenario. We need to provide for that. And that's one of the issues when you have young children.
I think a burning question, and maybe something that a lot of people get wrong. I mean, you'll see it just if you're reading through like the Reddit's estate planning forum. Some people get the impression that they have a trust.
Not a good place to get advice on anything.
Right. But that advice is out there nonetheless. So I just want to speak to it. A lot of people thinking, place. Oh, well, I have a trust, so those assets must be protected. So let me ask you point blank, does a living trust offer any form of asset protection?
Generally not at all. Your living trust is your alter ego. And a lot of people come in and they say, oh, I don't need to think about asset protection. I have a living trust. No, it doesn't work. Your living trust, if I sue you, I can take everything in your living trust. It's like water. It provides no barrier whatsoever. A living trust is a probate avoidance tool, and it's a great way to make sure that our assets goes to the people that we want it to go to in the manner and under the requirements or provisions that we want, under the timing that we want. But it does not provide any asset protection while we're alive. When I die and I transfer the assets to my kids, I generally never draft a trust that says, and distribute a third at this age, that age, and the other age. I never draft in my trust, the beneficiary can, demand, the money at the age of such and such age. Give the beneficiary no rights whatsoever. But you can make your beneficiary a trustee at a certain age when you want to trust them to do whatever they want. So instead of saying distribute all the assets, in 5 years, you say after 5 years, you can be your own trustee and allow the trustee full discretion to do as they please. So what happens is we have an irrevocable trust now, not my living trust. I'm dead and I've transferred assets in an irrevocable trust for my beneficiary. The trustee has full discretion, and my child is his own trustee. The beneficiary has zero rights, no right for anything. What happens in that circumstance is if my child gets in a lawsuit, files bankruptcy, the IRS is coming after them, they're in a bad business deal, whatever the case is, those assets are protected. That's the asset protection that you're looking for. And so those assets are protected because in most states, not all states, in Arizona specifically, and in some other states, the creditors have the right to exercise any rights the beneficiary have over their trust. If the beneficiary has no rights, then the creditor has no rights. Now, that beneficiary might also be the trustee. And as trustee, the trustee might have discretion to use the money to pay for whatever it wants to pay for. Well, now we've created a trust that's fully protected against creditors, and the beneficiary has virtual full ownership rights over the trust funds. And that's the best case scenario. If a client walks in my office and says, hey, we've been successful. We have $20 million of assets. We're in I'm an emergency room doctor. Emergency room doctors get sued all the time. I'm still making money. I want to asset protect my house and my investments and my money. Well, there's different things that we can do with the use of irrevocable trusts and limited partnerships and trusts in certain jurisdictions like Nevada or South Dakota or Wyoming. But still, the ability of us to protect the assets for a person while that person's still alive and have that person still be able to access that money directly or indirectly, the protections are not nearly as strong as when we die and we give the assets to our children in a specially designed asset protected subtrust.
What about gifts to grandchildren? My understanding is there's a special type of tax that's applied. I believe it's called the GST tax. Could you kind of walk us through how that works?
Okay, yeah.
How you get around
good question. So there's a thing called the generation skipping transfer tax. People refer to it as the GST tax. It's kind of a complex thing, really, in how it really works. So here's what happens. in the early 1900s, we have these super wealthy families, the Rockefellers and the Vanderbilts and the Kennedys, and then we have this new thing, this income tax and this estate tax, this kind of pops up, and so we have this estate tax now, and so what the wealthiest people, the Van Burens and Kennedys and Rockefellers, they then said, okay, well, here's what we'll do. We'll put all of our assets in a trust, and we'll hold them there in trust forever. And that way they'll never be subject to estate taxes, right? And they'll just continue to live forever and being owned by this irrevocable trust, and we'll avoid estate taxes forever. And then what will happen is those trusts will just get bigger and bigger and bigger and bigger. And this is really the purpose of estate tax. So what the IRS did is they said, nice little try, but we're going to come up with this thing called the generation skipping transfer tax. So if you put money in a trust and that trust benefits a beneficiary that is more than one generation removed, then we're going to tax it. And the tax is going to be the maximum tax bracket, the maximum tax rate at the time. And so what would happen is, if I had assets and I put them in trust and they were all for my great-grandchildren, well, there's a certain amount of money that I can give without the GST tax, and anything in excess of that is going to be taxed at 45% or 40% or whatever the rate is at the time. So there's a technique that we use, and we would we want to max out that GST exemption. So especially when we have wealthy clients that come in, and so had a client earlier today. I mean, they're about $120 million net worth. And so what we would do in a scenario like that, let's take that as for an example, is, well, when they die, we're going to put the maximum amount of money in an irrevocable trust that would max out their generation skipping transfer exemption. So right now it's $13.6 million is the maximum amount that you can give without there being an estate tax. And that is also your maximum GST exemption. And so what we would do with a client like this is we would actually make a transfer in trust, completed gift now. And we would tag that trust with the GST exemption. So now they've got two trusts, $13.5 million in each, that they've earmarked that are going to go for the kids, and then to the grandkids and the great-grandkids and the great-great-grandkids. And under Arizona law, that can continue for 500 years. And those assets can skip or will not be subject to estate taxes at each generation. Now, the rest of the assets we would put in, the non-exempt trust. So we break the trust like a living trust. We would break it up into what we call the exempt and non-exempt shares. But the non-exempt shares are going to be taxed at each generation. And so we would generally instruct in the trust instrument that the exempt shares, that's the place to build wealth and transfer wealth from generation. Let's buy growth assets. Let's buy real estate that's going to grow over time. And let's you buy a house, buy the summer house, live in it for free, right? And if you're going to spend money on consumables, well, that's going to come out of the non-exempt share, because that amount is going to get taxed at estate taxes at every generation. So you might as well spend that money on consumables. And so that's one way that we would build a trust to use maximum, effectiveness of the generation skipping transfer exemptions.
So it sounds like there's a lot of moving parts in the trust document. Would you say that it's important that when you are working with an estate planning attorney that you find someone who's going to be around to help your kids administer the trust?
Well, look, the problem is at that point you're looking for someone that is much younger than you and that person might not really have the experience to do the estate plan, you know, in the best way for you. So we can't, you know, hope that our trust lawyer is going to be there. I mean, we can hope, but you know, really, we're looking for someone that is going to put the best document in place, understands all of the provisions of a trust, understands various techniques to solve problems based on whatever the client's circumstances are. So that's really the estate plan lawyer looking for. And, you know, over time, we can always find people to administer these trusts. I mean, there's always going to be, you know, top estate plan and state administration people, but you really are going to need someone that knows what they're doing when it comes to the administration, because I've seen real good trusts get into the hands of people that don't understand what they have, and they think they have just the garden variety, you know, standard form trust, and they go down the administration role, and then there ends up being some type of dispute. And then we get involved, and we're taking a look at this, and we're saying, hold on a second, why did you do these things to begin with? The trust says all of these other things, and you kind of ignored it because you didn't know what you were looking at. And so that does happen. So you really do need, you know, quality professionals assisting you.
So you're saying as an estate planning attorney, your job is to make sure that all of the necessary provisions are in that trust so that whoever picks it up has the proper instructions.
Yeah, you know, I had a client come in, a friend, another lawyer, a couple days ago, and hands me his trust that was drafted, I don't know, 14 years ago by a lawyer that I know and was friends with. You know, he was an IRS attorney, and I was come out and of the IRS, and you know, so like a lot of the former IRS people who are in practice of law, we kind of gravitate and help each other out and talk about things, and so I liked this guy, and I was reading the trust, and it was just really difficult to read. I mean, you know, it was like so legalese and stuff out of order, and you know, it didn't go in a natural, you know, progression of you know, provisions. You know, it jumped around from how things work, you know, and it was just really difficult to understand. And I'm a trust lawyer. I teach this class to other lawyers, you know, across the United States. And I was reading this trust going, what does this actually mean? So, you know, our trust, anyone should be able to read it. So it used to be where, you know, lawyers got paid by the pound, I suppose, in the 50s and 60s. And so you saw these really long documents that were convoluted. Today, to be a good lawyer, you really want anyone to read that trust instrument and to understand what's going on, to know what to do. And so, you know, we try to draft our trusts as much as possible in layman's terms so that you read it and it makes sense and it says we're doing this. It doesn't go around the curb and around the block and underneath the, you know, the tree and then get to the point. It gets right to the point and says it in a way that everyone should understand. And I think that would be another important thing that I would look for in someone that's doing my estate plan is, you know, look at their trust instrument and, you know, read part of it. Does it make any sense to you? No? Let's find someone that knows how to draft something that, you know, when people read it, you know what you're reading. That would be helpful.
Thank you to all of our listeners for tuning in. It's been a great conversation. If you enjoyed today's episode, please subscribe to TaxSwitch Wealth Protection Podcast on YouTube and Spotify. If you have a question, feel free to leave it in the YouTube comments. If you'd like specific advice from Whitney about a tax or legal issue, you can request a consultation on Sorrell Law Firm's website at sorrell-lawgroup.com. That's SORRELL-LAWGROUP.com. Twice a month, Whitney and I will be discussing other exciting topics that you won't want to miss. But for now, it's time to say goodbye. Until next time, this is your co-host, Benji Albrecht, signing off. Take care and keep building that wealth the smart and legal way.